Hi, my name is Josh Bolin, and I'm the head of the litigation department here at Carpenter, Hazlewood, Delgado, and Bolin. This video is going to be a short presentation regarding the enforcement process and the enforcement tools that a community association can use in enforcing its use restrictions. When we talk about use restrictions, we are talking about the restrictions on a property such as parking, architectural approval issues, garbage cans, maintenance issues, gazebo issues, any type of different kind of things that you can think of that would be required for a homeowner to do to maintain or improve their property. First of all, before we get started, you're going to have to understand that there are two different types of obligations that the association has to do to enforce its documents. The first is the affirmative use restrictions. What is an affirmative use restriction? It's when in the documents the restriction says that the association must do something or shall do something. For example, the association or a homeowner shall not park in the streets. A homeowner must submit an architectural application before they make improvements to their property. The case at point here is Johnson versus the Point Community Association. And in that case, basically what came down to is an architectural improvement dispute where the Johnsons sued the association because their neighbor had failed to obtain approval. The court in that case found that when your governing documents have an affirmative clause, meaning that the association has no discretion, the association must enforce that provision as written. The only other option to that is the association has to amend it. If the association doesn't follow this, they could be subject to liability. The other one is, well, what if the association has discretionary language in its provisions? For example, if a document says the board may regulate where trash cans are stored or may park on the streets. That is discretionary. In Tier Ranchos v. Kitchikoff, the courts found that whenever there is discretionary power given to a board, the board must act reasonably in making its decisions. What that means, I don't know, but that is for a trier of fact to find out. So when a board must go through something, they must act reasonable. The good news is that the person challenging the action of the board and how they enforce this provision has the burden of proof to prove that the board acted unreasonable. So just a clear refresher, your obligation, you do have an obligation to enforce your documents. And if it is an affirmative provision, you must enforce it as written. And if it is a discretionary provision, you must act reasonably in enforcing that document. The next thing we're going to look at is your enforcement options. Essentially, association has four enforcement options. The first and most common is fines for violations. The next is self-help. The other one is injunctive relief. And finally, and one that should be used more often, is alternative dispute resolution. First, in talking about fines, this is the standard typical internal process that a community association may use to address violations. This is essentially giving somebody a notice that they are violating the documents, and if that act continues, the association then levies fines. Arizona statutes for the Planned Community and for the Condominium Act both address the association's ability to issue fines. The clear thing to understand here is that you really, before you can levy a fine, there are three main requirements. It must be after notice and an opportunity to be heard. Clearly, it has to be after. You can't levy the fine until after the notice has been sent out and the opportunity to be heard. So you have to do it after the notice and opportunity to be heard. So you have to do it after. You have to provide notice. You have to give the homeowner that is receiving the fine notice the ability to appeal that fine. After those may happen, the association then may impose a reasonable fine. We strongly suggest if you don't have a fine policy that you adopt one to address these issues. The next is self-help. Self-help is document specific. There's no law or statute in Arizona that gives an association the right to implement self-help. And when we say self-help, we mean go in and take remedial action yourself. For example, and most commonly, if there are weeds on a property, the association can go in if it has the authority under its documents and remove those weeds. The clear thing you must do, again, this is document specific. Most of the document provisions, so if it's not in your CC&Rs, you can't implement self-help, but most CC&Rs do have self-help. Those CC&R provisions typically require the association to provide notice and also give the association the right to assess those costs that it obtains or accrues through the self-help process and assess those back to the owner, and then may collect those in the same way you collect your regular assessments. Finally is the injunctive process. Going back to self-help, this is typically not recommended for properties that are occupied. And the reason for that is, there's liability in terms of someone coming out, trying to get you off your property. So we only really recommend self-help if the property is vacant. Moving on to injunctive relief. Injunctive relief is when basically you've tried to go through the fine process, you can't use self-help, and an owner still refuses to comply. Injunctive relief is you go to the superior court and you ask for the court to issue an injunction that basically obligates the homeowner to comply with something. Most times when you hear injunction, it's prohibiting someone from doing something. An association standpoint, it is an affirmative injunction that says you must comply with the documents. It's a piece of paper that if, for example, you must repaint your house, you must submit for approval, you must remove the weeds. It's asking them to do something, and that something is to comply with the documents. Good news about injunctive process, most of the time it's a 30-day first hearing after someone is served with it. It's an expedited process because with these injunctions, they kind of want to move through the court system pretty quickly. So the good news is with the injunctive relief, it's faster than your normal lawsuit. The good news about this is most of your documents and the Arizona law also states that if the association prevails in this because it is a breach of contract claim, they do have the right to recover their attorney's fees if they are prevailing in that action. And finally, the other option that not a lot of people consider because it's not really an enforcement option is the alternative dispute resolution. You can always meet with the owner to try to discuss the violation, to try to help them out, try to figure out why the association has the obligation to enforce its documents because the law essentially requires that, and a lot of homeowners don't understand that. Next, you can always try to go through mediation, have a third party come in. A lot of your local industry chapters such as CAR or AACM offer a mediation process. Some of your local municipalities also offer that. Or your documents may require you to go through arbitration, so it is also something you can check. Finally, we want to thank you for watching this. And as we talked about, this is a very difficult process to try to navigate. This is just a brief refresher of the enforcement process, what the association's obligations are, and the tools that they can use to get an owner to come into compliance. If you have any questions regarding these tools and how to navigate through this process, please feel free to call us at any time.